It is a quarter to the hour of 8 o'clock. I'm glad you're still with us here on Morning at NTV. It's time now for the Kickstarter discussion, and we shall be looking at the funding of the Judiciary, that is the third arm of government in the financial year 2024-2025 in light of the budget speech that was delivered to the country just a few days ago. The budget breakdown for this particular arm of government is one that requires a little bit of attention to detail, and with me I will be introducing very eminent persons who will be helping us understand exactly why particular allocations are done and to what effect that is envisaged. But first, our preamble: independent and accountable judiciaries are an essential component of high quality, effective and efficient justice systems across the world. Adequate funding is a key element in ensuring and safeguarding the independence of the arm of government and judges, because it determines the conditions in which the courts and the judges perform their functions. Funding is a wide issue, including allocation, but also local and national management of these resources. From this school of thought, we are attempting to interrogate the particular budget that was read by the Finance Minister, Matia Kasaija, and what it has for the judiciary. I'm joined, and I'll begin from my extreme left because of the dynamics of hierarchy. We have with us the Public Relations Officer from the Judiciary, His Worship, James Ereme Jumire Mawanda. Many thanks for joining us.
Thank you.
We're also joined by Ezra Rashande Ambasize, a lawyer with the Chapter 4 NGO and activist group. That's a controversial one. I'm also joined on my immediate left by George Musisi, a lawyer, and I'll leave it at that for now. Let me begin with the top honcho on set. That is the public relations. Yeah. I wouldn't want to be accused of contempt of court. All right. Yes. Mr. Mawanda, yes, the reading of the budget itself was much anticipated by everybody. Yeah. And of course, the judiciary must have been on tenterhooks to hear and to see exactly what kind of allocation was given to it. Before we get down to the break down what was given and the how of exactly where it's going. Yes. What was your take on the budget speech?
Of course, we want to thank the Ministry of Finance, and particularly His Excellency the President, because he has been at the forefront of supporting activities of the judiciary.
That's right.
And this time around, we saw an increase on the budgetary allocation, which is a very welcome gesture. You shall recall that a few financial years ago, His Excellency made a pledge and said the judiciary should be given adequate funding.
Adequate funding.
Of course, we use the word adequate considering other agencies that need money and other sectors. But one important thing is that he made a promise that every financial year we shall be seeing an increase, and I want to believe that we shall at a time T realize the 800 billion target which he promised. And for us, we welcome within the meager resources available to the nation, and all what we are going to do is to prioritize and to see how best we can improve service delivery. Otherwise, of course, we shall still say we need more. That one we shall not
Oliver Twist all the time.
Of course. We need more money.
That's right.
But we must also be conversant with the fact that the other sectors need funds, and also our economy may not necessarily be able to support whatever we need. But within the meager resources that we have, we shall apply the abundance mentality. Yes.
Okay, thank you very much. Very shortly, of course, we shall be understanding exactly what the specifics of those allocations are. Mr. Rashande, your take on the budget and specifically within the judiciary dockets.
Thank you very much, Chris. And good morning, viewers. First and foremost, the United Nations on 21st of March 2024 declared Uganda as a middle income status country following the impressive improvements that were referred from the World Bank and IMF. I think I will leave it at that. And this again state that it is one of the fastest growing economy in Uganda, sorry, in Africa.
In Africa.
Yes. That one cannot stop me from talking about exactly what budget is. A budget is a draft. It is a projection. When you're going to run a project, you always draft a budget. And it is always a projection. This money that 72 trillion, it is not merely that is the money that we have. When you look at the budget, 55.1, it is for debt financing. That particularly means we are going to be paying the debt on the budget, which is 55.1. And then we have 44.9 as domestic revenue that we have collected.
Within which the judiciary should also fight for.
Exactly. Now, if the accounting officer of this country stands there and says that they have allocated 481 billion to the judiciary, it means that they already have 44.9% on the money that we have. They are not going to receive 100%. I don't know whether you understand me.
No, I'm trying to...
If they allocated, if
yeah,
the money is for debt 55,
yeah,
it is debt financing of 72 trillion. Now that money has already been taken away. Now when a Ugandan look at 72 trillion, he thinks it's the money that we have and it's the money that they are going to give the judiciary. No, it is just to excite Ugandans and people who don't go down and look what the budget is and the meaning of the budget when you look it into the terms of economics. It is not that you have that money.
All right, that's an interesting one.
Yes.
But allow me, for example, because I have to keep this particular conversation strictly to the judiciary. I know the greater aspects of budgeting and economics do play pretty much into what the judiciary receives. But allow me just crafting George Musisi. And before we came on air, I saw there was a bit of not tension, but a conversation between you and his worship, the PRO, about pain points. But he was very, very emphatic and expressed hope that this particular funding that has come through could be able to address some of those pain points that you expressed to him. If you don't mind, we also want in on those pain points.
Sure, of course.
I don't know whether he means it.
For any Ugandan, of course, when they hear about budgeting, about the judiciary, if Ugandan is accessing courts or interacts with the judiciary in any way, they would be interested in just a few things. That how is it going to impact on my case? Is my case going to be heard faster because of the... So for so long, the people in charge of budgeting in this country, of course, have always not prioritized the judiciary or administration of justice as one of the key core areas. When people talk about middle income status, we are going into middle income, like the president always talks about it, and his minister of finance. Actually, access to justice is a critical component of any country to go into middle income. If a person has a dispute in court, for instance, His Worship was, since you brought in our conversation in the break, was talking about the issues in commercial court disputes.
Yeah.
If you have a litigation where a company which wants to invest money in Uganda is holed up in a dispute for over 5 years, it doesn't augur well for this country. Even you, at a personal level, if I have a land dispute and it's about my livelihood, and I take 5 years, even if I win the case. So for me, the key issue is, one, whereas the people budgeting actually need to prioritize the judiciary. When we're prioritizing, just like we're prioritizing security, infrastructure, administration of disputes, and people accessing justice smoothly. Many times we're talking about the National Legal Aid Bill, which has been stuck for so long because government says there's no money. What that means is that almost 80% of people who access courts don't have legal representation. They cannot afford it.
That's right.
Others don't even come to court because they don't even cannot afford it. So those are some of the things that an ordinary person would be interested in knowing, that, okay, if they're talking about funding and how is it going to help, then after giving them all that money, then we can turn our guns to His Worship. Of course, I mean him figuratively, the institution he represents. With all this support you've been given, can we have cases disposed of in 2 years? Why should you have a land dispute taking 5 years in court or 6 years? Even if it's a temporary matter where I'm seeking an injunction, it takes 6 months. So sometimes, as people access courts every day, we know that sometimes things are beyond their control. You have a judicial officer handling over 10 cases in 1 day. So some things are humanly impossible. So for me, I think that there is need even for prioritizing, looking at judiciary, just like we look at infrastructure development. Otherwise, we can never dream of middle income when we've not sorted the issue of access to justice and administration of justice. So,
gentlemen, we shall be hearing a lot from His Worship, because ideally he speaks on behalf of the institution. But I want to understand, how far is it down to resources for justice to be dispensed effectively and quickly? He speaks of the fact that some disputes take longer than necessary. I've also been able to observe, within the context of my own work in the media, where certain disputes are settled so expeditiously, and then others that the naked eye seems to see as cases that can be solved as expeditiously as those that have been settled, taking longer than necessary. Is it down to the politics of the day, or it is a case, again, if this conversation is anything to go by, a lack of resources?
Thank you very much, moderator. First of all, I want to state, categorically, that in case management, there is no politics. At least the politics that I want to think is what you mean. Here we have clear policies on how to manage cases, and also including case backlog. But the most critical aspect here is resources. When we have less resources, surely we can't do much. Resources, financial, resources, infrastructure, ICT, etc. All those resources impact a lot on case management. To go specifically to what my brother has just been saying, we as a judiciary, recognizing, the cries of the citizens of this country, the cries of the people in Uganda, the judiciary has come up with a lot of innovations, even amidst those meager resources. Delays are not as a result of the politics, like you say, because you have also mentioned expeditious cases. There are cases that are complex in nature, and my brother Michibu will agree with me that however much you have the money, you must allow the justice of the case to flow. When you hurry it, you might bury justice. At the same time, there are those sensitive cases that must be expedited. Election petitions, for instance.
Whether justice is buried or not.
No. That's the law. That's the law. The law provides that they shall be within a specified, period of time. And we must do that. Then they are also, the courts are enjoined with the capacity to look through cases, okay, and prioritize them. The prioritizing leads probably to what you are saying, that others are expedited and others are
not.
But it all goes to what's the nature of the offense or the case, maybe civil or criminal. What impact has it on the society and the economy, that its further delay will have other dire consequences. So the judge in charge of such a matter will, or docket will prioritize. Okay? If I have a case involving an elderly woman, okay, without necessarily saying that a youthful person should be disadvantaged,
shouldn't be considered,
but common sense will demand that let me attend to this elder, okay? So many other factors surround how we manage cases. However, when we have resources, when we have money, and this time around we want to thank the government. Everybody is crying because of little resources.
Little resources too.
Okay? The Honorable Chief Justice and top management had to go and make a case and say, Ugandans, we had a National Court Open Day. You remember I was here and talked about it, and you heard what the people were saying.
That's right.
You also heard what the Uganda Law Society was complaining about.
There was that
and we don't give a deaf
meeting
ear.
you had, was it at the Sheraton Hotel?
We don't have a deaf ear.
The bar and the bench.
And even civil society. Everybody, commercial court. So, I will tell you the other aspects that we are going to consider and prioritize the recruitment of the judges of the justices of the Court of Appeal. Parliament allowed and gave us and increased the numbers, okay? And we are decentralizing. We want to have at least, for starters, Guru and Imbarara, Court of Appeals. We are going to use this money for that recruitment and also construction of those courts. Equally, we are going to have the construction of other Chief Magistrates Courts and Magistrates Grade 1 courts. Okay. You remember we just released a new instrument number 11 of 2024, increasing the number of magistrate areas, every district, including counties and sub-counties and municipalities.
That is right.
Taking services closer to the people.
Yeah.
And in so doing, we are addressing issues of delays, we are addressing issues of distance, we are addressing issues of service delivery. In addition, we want to do ICT. You know what ICT does.
I know. But that's something that we shall be tackling a little bit later independently, because it lies under automation of judicial processes, which is very critical, especially when it comes to achieving expeditious dispensation of justice. But gentlemen, listening to his worship, of course, I do know he addresses some of the concerns you may be, of course, have spoken about. There was that particular meeting between the bar and the bench. I know there are so many issues that were put forth. I do not know whether the bench actually came through in addressing them. Any of you was part of those meetings?
Yes.
You were? Were you? You weren't. Were those issues from the bar end down to aspects that could be as a result of a lack of funding of the judiciary, or it was a case of your own gymnastics within the law?
We love to have that feedback.
Of course, every service provider, every time there are always complaints and a number of issues. And of course, those complaints are usually more where you have aggrieved people, because very few people go to court happily. Many people go to court when they are aggrieved and lots of issues. That's right. So a number of issues came up. Some of them could be resolved in the immediate. Some are longer term. Some, yes, are due to funding. And of course, whereas I join every other Ugandan in welcoming the increase in the number of judicial officers that His Worship has so quietly elaborated, including the number of courts and extent, because it does help in bringing justice closer to the people.
That's right.
But of course, sometimes we also have questions as to the actual operations, and that is where we turn the guns on His Worship, and I mean figuratively, Judiciary. That sometimes even when the court is brought close to me, we would like to see court begin on time. We would like to see judicial officers present. We would like to see judgments delivered within some guidelines the judiciary gave. So that yes, the first plus is we've got the center here, the justice center. We've got the court closer to us.
That's right.
But now we would also like to see an improvement in terms of the management and case management of the cases, such that it's not just ticking a box that we have more courts, but actually even case disposals are brought. But then again, it's also important to note, Chris, that judiciary is the way it works. It can't work alone. For instance, if it's a criminal matter, judiciary relies so much on matters brought through the police, the DPP. Right. So if there is no incremental increase in the DPP's office, you find that you have one judicial officer or 3 judicial officers at the court, and then you have one state attorney. So cases will stall because the state attorney is with another magistrate. You have to wait. This one is present, the judicial officer is present, the lawyer is present, and the litigants, but then the DPP. So the government has to look at it as a chain, the administrative justice chain, that work on police officers, work on DPP, work on judiciary, work on prisons to ensure that, and then work on the legal aid issues as well. That is how the wholesome access to justice will be achieved eventually.
Okay. Mr. Rashande, human rights legalities have been a major issue, especially now, and I do know that cost of legal officers is something that is always a bit of a problem for those that are seeking justice within that particular stance. In light of your station as a human rights lawyer with Chapter 4, the NGO, I do not know whether the budget looks at aspects that will enhance the process, especially for those that are involved in cases of human rights abuse. Is it something that kind of appeals well within the workings of the legal professionals who are in the human rights docket? I don't know whether that actually comes through as correctly or as clearly as I want it. But I do know that many times human rights cases do make the bulk of cases across many courts, and then issues come in here and there. What's your take? Just take us through exactly what you deal with.
What I would like to state is that the right to legal representation is provided under the Constitution, that is under Chapter 4, Article 28. Yeah, everyone has a right to choose or to hire a lawyer of his choice. And there is a law that regulates overcharging and undercharging. That is advocates' remuneration and taxation of cost rules. Yeah. So cases that, and then when it comes to cases that have high magnitude, the law entitles them to have a lawyer. I'm talking now to criminal. For example, where there is a long sentence, for example, the long sentence, I'm talking of life imprisonment and death. The government always provide the lawyer, a legal officer to represent him. That is Article 28, Clause 3 of the 1995 Constitution. But now here comes where there is public interest litigation. The public interest litigation is where it is provided under Article 50 of the Constitution, the 1995 Constitution. This is where there are very many people, they have an issue or a matter, but they feel like they cannot represent it, or they don't have money to hire a lawyer. This is where the civil societies, or I can call them NGOs come up, because they are there to fight for the human rights of the people, and they come and represent. We have seen very many matters that different civil societies have been engaged in, and that is a right of expression, right to a fair hearing, something like that. There are very many cases and precedents where the civil societies, and particularly where I come from as Chapter 4, has been there. And for us, our job, it is always to make the space bigger when it comes to the rights, and then to the rights of the people and liberties and freedoms to keep upheld by this government.
This is a question that I will require that His Worship Eremi also does give us his perspective. But from your point of view, when it comes to provision of legal officers for persons that are unable to afford lawyers, for example, what is the state of affairs? Is government providing these legal officers? Before the need for human rights lawyers who are working within the civil society come in, what would be your report card on that? On that,
the law is clear on that, but there is always controversy and lack of trust by those people who have been alleged to have committed those offences. That the government, the officer from the government, may pass behind and maybe not represent him well. As you know, for example, like a case of terrorism, like the case of, yes, that happens. Or if the case of terrorism, the case of, you have seen where Ugandans have been implicated just for that, even when it's not. Just that he has been participating in he has been practicing his political rights. But out of nowhere, they come and say he's a terrorist. And then, so you cannot, someone who is from NUP or Anti or from FDC cannot really trust.
Your Worship, I beg your indulgence. Let me first engage Judge Musisi on that issue, because is it possible, for example, for the DPP to provide a legal officer, and this is a prosecutor, to represent a person, for example, who has an offense and it's widely seen to be against the government, for example, treason? It could be a political activist and they are alleging human rights abuses. What is the kind of trust dividend that a legal officer or a prosecutor does provide to this kind of client?
Of course, there is the constitutional mandate of all these offices. For instance, you cite DPP. DPP under the Constitution is supposed to act independently and without the direction of anyone. And we understand the constitutional mandate, and sometimes we understand the context, the political context within which they are operating. Sometimes there are some contestations. And many of us always try to urge these offices and support. I'm one of those people who have always flagged to support the independence of the judiciary, despite all those pressures. And of course, I know that there are many times when judicial officers have tried to withstand and fight for their space, for their independence, because an independent judiciary benefits each and every person, irrespective of political affiliations. But we should also be mindful that of the environment, that sometimes there are overzealous actors who try to push these institutions. So the onus is on the institutions to withstand those pressures.
All right, Your Worship, those are very pertinent concerns when it comes to first of all, the cost of legal officers, but also the sheer trust that a person being represented by an officer from the DPP trusts that that officer will be on their side without necessarily putting them in a situation where...
And sometimes they're just actually perceptions.
Perceptions,
are also important, but sometimes they're just perceptions. They can't be real.
And also, trust is important.
Yeah, the trust dividend.
Client,
Your Worship.
First of all, allow me to thank Uganda Law Society
Okay.
This time around, we are speaking the same language, and I'm very happy that he has even given us feedback. I've been taking notes. Okay, I've been taking notes, and this is the networking, the partnerships that we were talking about.
That is right.
All along, which even led to the Bar Bench Forum that you also mentioned, and where I was speaking very good feedback. But I want to also thank the president, okay, for ensuring that our message is received in good faith, and we receive their messages also in good faith too. Even chapter 4, these are very pertinent issues, and we receive them in good faith, because it's only then that we are able to put right what may not be going wrong. Secondly, specifically, if we may allow, before I go to the other, he was raising the issues of having courts, but without time management, presence, okay, delayed judgments, etc. I want to inform our viewers that when the AJA, the Administration of Justice Act, came into force, the Honorable the Chief Justice has appointed several committees, okay, and these are intended to assist him in the management and administration of justice, and they report him directly, they make proposals, etc. One of these committees is on inspectorate, okay, and case management. Now, regional inspectorate court offices are going to be opened up, and there are many purposes to check on those concerns. We have already told our people on time management, we shall not compromise on that. We want people to be at courts, okay, in those as far as the constituencies are concerned. We want them there. And judgments, the inspectorate supervision, monitoring, and the supervision is going to be enhanced because of this funding we are talking about. And at the end of the day, we want to assure our law society and the public that we are not only speaking, action is already on the ground, committees are already in place, and we are moving on. Legal aid. Now, legal aid, first and foremost, what's the mandate of the Office of the Director of Public Prosecution? This is prosecution, okay? To prosecute people on behalf of the state. But what happens in the court setting is that the accused person, okay, has a right to legal representation, as my brother has said. But also, the state has a responsibility, okay? While the accused person can reach out to practicing advocate, like my brother here, Muchim, okay, and give him instructions, okay? Equally, the Law Council and the Uganda Law Society have required that lawyers in private practice should also have pro bono service, and credits are issued for their
pro bono service licensing. At law firm level. At
law firm level.
Okay. Not within Uganda Law Society context.
No, at firm level. Law Society is a supervisor, Law Council is a regulator, okay? Then, as government, the state, we have now what we call the state-funded legal representation scheme. State-funded, okay? The state, this is a work in progress, okay? And I want to tell our listeners that the legal aid specifically, which we are looking at, especially in criminal matters, because that's where there are issues, okay? There are issues there. The state-funded legal representation scheme is by government, and the courts of judicature, the judiciary, is spearheading the frameworks, okay, where our good lawyers, okay, and many have enrolled. I don't know whether, have you enrolled? Because I don't want, I will go and cross-checked, because I don't want to see you off that list. But we are working with Uganda Law Society.
Now I understand why George Musisi has overemphasized your worship, your worship.
Yes, he does. We are friends.
All right.
And very positive friends. Okay. So what I'm trying to say here is that we have actually lobbied the Uganda Law Society and its membership to join this scheme.
That's right.
Okay, so as to improve that aspect where the legal representation of these people can be adequately achieved.
That's right.
Now, on human rights cases. Ideally, we know and agree that human rights cases are very important.
That's right.
To society, they inform policy, and a lot of things, okay? And when they come to court, we equally give them the priority. Unfortunately, still, we have lots of caseloads, okay? Lots of caseloads. And when we tell this nation that we need more judges, we need this funding, we need these courts, especially at the level of High Court, okay, and the Court of Appeal and the Supreme Court. It is to focus on those fundamental questions. With numbers, I want to assure you, we reduce caseloads. Did you know that the ratio of a judicial officer to the population, okay, prior to 2020 was 1 to 160,000 plus people? And that is impossible to be able to give the best service you can. With now the recent recruitments of magistrates grade 1s, chief magistrates, judges of the High Court, and now the Court of Appeal, we have achieved a reduction from 160,000 people to 1 to 80,000. Okay, but we're still saying that is still high, considering the rest of the sub-Saharan Africa. Theirs is even lower. So let us have the numbers, let us have the funding, and progressively, if we can have more money, and my brother Msisi, okay, and him should join the bench. Please join us.
These are young men.
Yes, and we need young blood.
Yeah.
We need the younger people. But we want the competent ones. Yeah, those who are professional and competent.
Okay, it's a good point. And allow me just quickly ask a question regarding to the transition for lawyers and advocates, for that matter, from the bar to the bench. How is this? Is it something that is attractive? Is it something that perhaps you have constraints in attracting some of these very young people onto the bench?
By the way, the mistake is us using the word attractive and attraction. This is a calling. This is a service. You see?
Wait a minute.
Actually, those who are coming into the judiciary because they perceive some attraction. I think they are the wrong elements we probably may be getting. We want people who are committed to serving this nation. You see? Now you can hear, you know? And of recent we have seen... You will
forgive the public for the perception, but when you see lawyers and the conduct of duty and the glamour and the flamboyant nature with which they do their work, you begin to think that often it's difficult for a lawyer who is into the trappings that are in a law firm, especially if it's doing good business and it's getting all the clients, to want to transition to be a magistrate.
You may want to know, in the recent past, how many lawyers,
maybe
advocates have actually crossed into the bar.
Wow.
Actually, they are the majority. Okay? Which means that the attraction is there. And for us who have been in there, we have been there because we came to do a service to the people.
Okay.
Now, the other question is, as we have those wonderful, good friends from the bar joining the judiciary, okay, and they have been noticing those inefficiencies we have, we want them to come and improve with us. That's why I'm asking Muzisi to come, I'm asking my brother to come, because they know where the issues are, and once they join us, then we shall address the problems, for as long as they know it is a service, not by reason of attractions. Okay? Because the moment you are driven by these attractions, then you lose the sense of responsibility. We need to serve our people with a conviction, with a vision, and then see that the image of the judiciary is. But if we are driven by attractions, we shall have a problem.
Justice might be undermined.
Of course.
All right, gentlemen.
Of course, remuneration is very key.
That is the undertone that attraction, you know, attraction is an undertone to
for
remuneration.
For him, he can do lots of things at the bar.
Yeah.
But at the bench, you are there for service.
Okay.
Okay?
That is perfectly
So you have
understood.
to be remunerated for you to be effective and efficient in your service delivery.
All right, gentlemen, let's transition on to automation and the ability for the judiciary to be able to work within the abilities of what technology can do, and of course ensuring efficiency, reducing human contact, and as one of the tools touted to reduce corruption. Corruption is one thing that we shall be discussing on the tail end of this particular Kickstarter program. How is the automation regime around about now?
Of course, it's every piece of technology comes with its own challenges. But in the bigger scheme of things, we know that globally the world is moving towards automation.
That is right.
So we've seen the judiciary, at least around Kampala, for quite some time now, I think 2 years now, they transited to the ECMI system, what we call ECMIS, the electronic case management system, where you have you can file a matter remotely, and this of course has had its fair share of advantages in terms of tracking. Of course, the transitioning period was quite sudden, that some lawyers are grappling with it, just as maybe some judicial officers are grappling with it, because sometimes if the intention is to reduce human contact, you find that sometimes you file a document, but then you have to follow it up to see that it's fixed, or if you don't follow it up, then it may take in some time hanging there. But of course, these are challenges that are expected with every transitioning period. For me, I prefer to look at the bigger picture. Of course, the bigger picture is that that is the way to go, and of course, it's now to be seen how to catch up for all of us court users and the courts, because if the intention is to reduce human contact, then let us fully utilize it to ensure that human contact is reduced. Okay. So it takes two people, the person who is filing and the person at the other end, because sometimes you find that if you've used and you filed, then you have to make a lot of steps in following up to ensure that the other end has also acknowledged and then done of course, there are some judicial officers who are on point, who have fully embraced it, and this I think in the longer run, I think it will have a lot of advantages.
All right. Judge Musisi, that submission takes us into our break, but when we return, Your Worship, you will have to update us on the latest interventions to ensure that automation is achieved in order for justice to be dispensed easily without necessarily the troubles of human contact. We'll also hear from Mr. Rashande. I want to particularly put this to you on the implementation of alternative dispute resolution mechanisms and how that is going to help reduce on the load that the mainstream justice system has in ensuring that some of these cases are disposed of. Let's go for a break. You're watching Morning at NTV. It's the Kickstarter, and we are trying to break down what the budget, which is a staggering 481.4 billion Uganda shillings that was given to the judiciary, will do, what it can do, and how it will be able to ensure that this dispensation of justice is improved in the country. We'll be right back. Stay with us. Welcome back. We're glad you're still with us, and if you're just joining us, welcome on board. We now have all hands on deck. When we went into the break, Judge Musisi had just submitted on a very pertinent aspect, and I promised that when I return, His Worship James Eremye Jumire Mawanda shall again be able to brief us exactly on, very briefly, on how the automation process is being undertaken and what exactly has been achieved, very quickly, before we have Mr. Rashande take us through the alternative dispute resolution mechanisms and what that means for justice dispensation. Let me begin with Your Worship.
Yes. First of all, I want to say that automation is the way to go. World over, as we move into the 5th industrial revolution, we can no longer work as of yesterday. So automation, and of course, for obvious reasons, efficiency, effectiveness.
That's right.
Reduction of human contact is very key in the fight of corruption, particularly in all government institutions, not only the courts, okay? Why? You have heard of the usual cries of the public. You go to ask for this because you are going to pick a hearing notice. Somebody, may not necessarily be a court staff, but somebody around the court takes advantage and picks a 10,000 from a litigant. Okay? My brother Msisi was already complaining about the delays in receiving hearing notices. But automation, specifically ICMIS, which we are using now in the course of judicature, is intended to facilitate the fast processing of all of that which takes for a progress of a case. Now, why are we insisting in automation? And what are we going to do with the funding that the government has given us?
Just provided,
provided for us. We are going to increase and bring more courts onto the portal. Okay? When we have more courts, we have more efficiency. This ECMIS automation has even helped us improve on revenue collections in terms of fees and etc. Forgeries, counterfeiting documents, etc. have all been done away with. Okay, my brother Mushishi and chapter 4 can easily go onto the system and track their case. They know the position. At least they can access information. Unlike when they have to spend money to go to a particular court physically and look for information, which information they may not readily find. Now, we had the cluster 1, cluster 2. We are now moving to cluster 3. With the continued funding in specifically that area, and which His Excellency has emphasized, we are going to ensure that we connect most of the courts. But as we do connect, you know, we depend on the national internet provider, NITA. So there are places that where internet may not be easily readily available, and the other service providers may be very expensive for us. So we need to move in tandem with the other providers. That is what my brother said earlier, that you see, the administration of justice is not all about the judiciary alone. We have other factors. But we set the bar, we set the pace, we want to move that direction, and we are really very eager to continue in that direction.
Okay, very quickly.
Reduced corruption.
I hope this answer can be delivered to us in a sentence. Do the prisons have the technology to ensure that the suspects that might not moved from far-flung prisons are able to interface? Yeah,
so far we have already done video conferencing, and facilities have been put in say Luzira, Chitalia, and all these other regional prison facilities. We are able to actually sit in the courtrooms, and we have the court trials with video conferencing facilities already available. So with more money, of course, we shall be connecting more prison facilities. Okay, and with the stable internet.
Yeah,
that's another issue.
Nira is listening.
Nira is listening.
The executive director and some of the honchos there do watch Morning at NTV. I hope they can give us steady connectivity. Mr. Rashande, the alternative dispute resolution mechanism, I know there have been many interventions, including plea bargaining. It has its cost to it on the part of the judiciary. First, how feasible or effective is this in addressing that particular challenge, and has it come at any cost? If it has actually come at a cost, what's the burden to the taxpayer?
So, thank you very much, Chris. To the alternative dispute resolution, I think it refers to the different ways people can resolve a dispute without going to court or without trial. And we have seen cases where the first and foremost, the ADR, we have mediation, we have arbitration, we have neutral evaluation, and that makes it more or less formal to a local citizen who feels like the formal way of going to court will bring him to stress and even high cost. And sometimes he doesn't have that money to hire a lawyer, but he can use that ADR, or so that to run the case very fast. We have seen we have had very many challenges with court, where the case goes into court and it takes 10 years. But
longer than
exactly, and all those are expenses. That is a lot of money that is being paid to the lawyer, and even you personally as his client. Sometimes you are needed to travel from one place to another, and those are too much challenges. But where ADR has come, we have to embrace it as Ugandans. By the way, it shouldn't be. It should not have come today. It should have been here for a long time, according to our economy and how we are standing. And ADR helps us a bit. It is flexible, it is cost efficient, time effective, and it gives the parties more control of the process and the results. So there is too much trust in ADR than even court when you come to the citizens, because he's intact with the other party and the mediator, or I can call him arbitrator. So it is so much important to embrace ADR, and I wish to thank your worship to come up with this line of ADR, because we needed it so much than now running to court with the case backlog that we have there. The ADR will reduce all that, and even the money that has been there, 42 trillion you talked about, it is going to be, it will come as a solution, because the judges will get time to resolve those matters, as other matters are being lined in mediation and arbitration.
Judge Musisi, my own understanding and following up of the alternative dispute resolution is much founded on conflict and peace mechanisms, especially after war. When I was younger, we heard about the matoput system among is it the Acholi or the Lami? And it seemed to be a very effective way in resolving cases including murder. However, as time went on and as the dynamics of society changed, there is a tendency to feel like if people begin to understand that ADR on murder cases can be undertaken, then it kind of fuels the urge to commit certain crimes, because you know you're not in for the harsh sentences that the courts of law will provide. I don't know how the judiciary navigates this very, tricky path. And I know His Worship will be able to tell us more about that. But what's your take on the ability of ADR to effectively help the mainstream judicial system to be able to expeditiously deliver justice?
Of course, ADR, if well implemented, the different facets of ADR can go a long way in even reducing the backlog. Recently I read that the High Court has commissioned a number of judicial officers, judges, to even mediate over some cases which are in dispute. Some of the challenges that have made the previous practices before were not necessarily because of the nature. But for instance, one time Judiciary brought what we used to call the quarter next mediation, that a civil matter, before it goes before a judicial officer, it had first go through a mediator. It was a good plan, idea. However, it met the challenges of resources, that sometimes some courts didn't have mediators, some courts didn't have, you find that a judicial officer is the mediator and then he can't hear the matter. So there was challenges of finances, the challenges of even us lawyers, all litigants, appreciating and fully embracing, and so many other challenges. But then I just want to talk briefly about what you mentioned, that sometimes some of these ADR systems in our cultural norms and all are well grounded. However, the judiciary as it is, first of all, its duty is first implement the law. Yeah. Then can only get in other practices if they don't contradict with the law. Yeah. I remember the case you said, for instance, you've talked about Matoput. We saw it almost clashing with when Justice Mobile was confronted with the matter of Kanyamunyu. Remember the famous case of Matthew Kanyamunyu, where they were going through an ADR process, and then some people thought that the ADR would have an implication on the matter before court. And so the harmonization is there, but sometimes if it automatically clashes with the law, with the written law, the judicial officer is under duty to first implement the written law before you go into customs. And I know that the CJ we have, the Chief Justice, is a good support of ADR and all. So we need to, one, fully embrace it within the law. It starts with that, and then also going through a gradual process of teaching the general public that this may not necessarily be a let-off, but it's some sort of justice, because litigants are used to adversarial justice. Chris, if you hire me as your lawyer and you see me talking to Mr. Ambassador here, who is an opposite lawyer, you'll even say you are compromised
at that point.
Smiling,
I'll be like, how does that happen?
It's even worse, you know? If they are talking to the judge,
you know,
and yet they are officers of court.
So you're going to be fighting.
Yeah.
So sometimes it's a matter of perceptions.
That is right. And mindset is something that is very important, especially across board from all stakeholders within the justice system. The operationalization of ADR in light of already existing law mechanisms seems to be a challenge, but maybe you can tell us exactly how it's being done and whether at any one point in time it can be a let-off.
Thank you. Of course, we need to tell our people that ADR has many facets. Okay, we have mediation, we have arbitration, we now have plea-bargaining in the criminal. They also have in the commercial small claims procedure, and then we also have reconciliation and other forms, okay, of ADR. And I want to start with particularly the aspect of the Kanyamunyu case, okay? And I want to tell the public that in the court so doing their work, they look at justice and fairness, okay? Now, justice is not only for the accused person, but it's also for the victim, and also for the community, and also for the nation together. What broadly came out in that case of Kanyamunyu was the ADR and reconciliation. Okay? You know, Article 126 broadly allows the courts to ensure that they promote ADR. And in this particular facet, I want to talk about the reconciliation. Reconciling with the victim's family, the community, and the nation at large. And I think it was achieved. But again, the object of punishment, okay, this was a murder case. All right, and that is what Mr. was saying, that there must be a balance, okay? What would happen if Matoput was allowed to supersede the law, okay? Probably would have people committing more murders. After all, they will go for Matoput. It happens in Karamoja, it happens in all these other places where somebody is murdered, they take cows, and the state police cannot allow that. So, by and large, the judge handled the case. It was welcomed, and I think Kamunyu is already out of prison, and he served his sentence, and he can now not be accused of anything. The Honorable Chief Justice, Alphonse Chigamoye Owinyidol, an ardent supporter, and my brother has mentioned that. We had the whole summit of Chief Justices on ADR of Africa, here in Uganda. That's a commitment that we want to have alternative dispute resolution. In fact, he wants to change the definition. It is African dispute resolution, mechanisms, because they are very rich.
Not alternative.
Not alternative. In fact, he
surely
has stated
it actually makes sense.
He has stated it categorically that actually this system we are having, the one of robes and etc., is the alternative. We had the African, okay? So The beauty with
a
Africa,
discussion that can
a
end
very rich discussion.
a century from now.
Yes, and I want to tell you this: we are working in progress to look at, go back to look at the mediation rules, like he said. Okay, we have realized that mediation, when we made it optional this time, okay, might still have issues. But the Rules Committee is looking at it, and we shall be advised entirely. Last 2 weeks ago, the Honorable Chief Justice actually launched and appointed court mediators. And these are a wealthy, experienced, retired judicial officers and advocates, okay, who are out there and were having probably informally doing this work, and we are saying, you know, let us harness it formally back into the system, so that our people can have the service of mediation and ADR at large. So all the judicial officers are on board, and it is very good to encourage anyone who is, and that doesn't mean that other mediators or ADR facilitators are not welcome.
All right.
We are moving that direction, and we are ensuring that, in fact, they were all even posted. He did the posting and attachments to different courts. They had their first inaugural meeting, actually, last week or this week. I may not be. So the direction of ADR is very healthy and positive. We are encouraging our judicial officers to ensure and participate in ADR, and we know how ADR can perform wonders in case management and case backlog. If I brought you statistics of those very notorious cases, which ADR has helped us to unravel, you will be shocked. One of them is the Ham case. Did you know that?
Okay, that can be a discussion for another day. Time is not our best ally. Gentlemen, many thanks for the perspectives. They have emboldened our understanding of matters, most especially the cost when it comes to the dispensation of justice, and the how and the what that the judiciary is undertaking to ensure that every Ugandan can be able to access justice as and when needed. His Worship, that is James Eremye Jumire Mawanda, Public Relations Officer at the Judiciary, many thanks for making time. Many thanks to you too. Ezra Rashande Ambasize, lawyer with Chapter for Uganda, and many thanks George Musisi, a lawyer, for also ensuring that we do have your perspective this morning. That will do it for Kickstarter. I'm Chris Higenyi. It's been a pleasure having your company, and for the team that is responsible for ensuring that these 2.5 hours are as exhaustively informative as they are Monday to Friday. Many thanks for a good job done. Well, that's it. Have yourselves a lovely day. I'll see you tomorrow.